to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday morning at 10 a.m. Pacific time. And in deference to our guest, Jennifer, at, it's got to be noon Central Time, right? There you go.
Yep.
And we talk about all things related to estate planning, the administration of trusts and probates, both from standpoint of doing your own estate planning, as well as for professionals who are involved in this area or are considering becoming involved in estate planning and trust and estate administration. So my guest today is all the way from St. Louis, Missouri. I was telling her that's where my dad was born, is Jennifer Belmont Jennings. She's with MGD Law, and Jennifer has a varied background. And so, rather than me, going into a long, elaborate thing, I'm going to have Jennifer talk a little bit about her background first, so you can see just how much she brings to the table in her practice, and then we'll kind of move on from there. So Jennifer, thanks for coming on the show. Really appreciate it.
Well, thank you for having me.
Yeah. So share a little. On your LinkedIn profile, I've read your background. Share a little bit about some of the professional activities you've been involved in addition to now being a lawyer.
Sure. So I was a financial crisis law school grad. So anyone who's in this field from back then, that just says all that needs to be said. And so I think my path has been a little bit different than I anticipated when I started law school. But, I started out earlier in my career doing estate planning and family law, and then needed to make a change for a lot of reasons. You could read about some of that in Women in Law, Discovering the True Meaning of Success, a book I contributed to. And so got into the financial services for a while, for almost 10 years, and obtained the certified financial planner designation. And then just through a series of events, I ended up making a change and am back in the estate planning area, and ended up in a great boutique law firm filled with a wonderful, lawyers. And so I am focusing primarily on estate planning, tax, helping people with that, but also bringing in some of the financial planning, background that we have, because everything is very interrelated. Everything with the tax, your investments, financial planning, your estate planning, that's all really intertwined. And so I'm not doing anything investment related, anything like that, where I have to, maintain like registration with the state on that kind of thing, but really trying to use a lot of the knowledge and experience that I gained back in the financial planning world, and trying to help, merge those parts of people's lives together as we, create and then implement their estate plans.
So, and I think it's important to note, this really distinguishes you from a lot of lawyers in this field, because although you, as you mentioned, you don't, do the actual, wealth management, having been in that industry, I suspect you understand it quite thoroughly and at a level that many attorneys may not.
I like to think so.
So I can say it. You don't have, you may want to be modest, but I don't have to be for you.
No, I think a lot of things come up, and it has already been very helpful to know, like, oh, that particular brokerage firm, they're not going to like this. This is how we have to approach it. This is probably what their documents say, in that account agreement. These are the ways we need to navigate this or that. So it actually has been really helpful that I have the experience on what's happening on that broker dealer side or the investment advisor firm side. I think it just helps with efficiency a little bit more, because I don't necessarily have to ask a lot of the questions that some attorneys might have to ask, because I already know what the process is and what we probably need to do to get our ducks in a row in order to make this faster and easier on the clients.
Gotcha. So I think one of the things about your practice is that you really look to help people preserve their legacy. So if you would unpack that for us, when you talk about preserving a legacy, what does that really entail?
It can mean a lot of things, right? Some people think about it as money, right? You've spent a lot of time earning this money, or maybe it's been passed down, from previous generations. We work with a lot of people with, multi-generational wealth. It can be money. It could be just that you have a presence, right? You could have a charitable presence in town and, dedicate your time to philanthropy, and you want to continue that legacy. It's your name, and your name can mean a lot of different things. And so what we want to do is help people see how, what they have worked to achieve is really important and deserves to be protected. And your family is your legacy. That doesn't have anything to do with money. Raising your children to have certain set of values and to carry on traditions and things that are important to you. Those are all really important things to do. And your children, your family, is the one that's saddled with all of the stuff that happens when you die. And you can make it easier or harder for them, right? You can't make it perfect, because there's perfection does not exist, but we can certainly make it a lot easier for them, and help them to ensure that things continue to go smoothly, that your name still has the impact that it wants, that your family, that your money is preserved the way that you envision it and goes to the next generation the way that you envision it. So I think we start by having those conversations and getting to know our clients and understanding what they have, what is important to them. It's not as simple as just plopping out a document, right? People want to act like this is just like go on the internet and print this out. It is so much more than that, because people are different, right? We're not all the same. So we have different values and beliefs and goals. And so we want to help make sure that what's important to you gets put on paper and then actually happens.
Right. So in my work, actually, this dates back to when I was in the Navy. I worked as a chaplain. One of the things I found is a lot of times people didn't really understand the kind of things that you were talking about, especially the non-monetary aspects. So how do you work with a client to really help them understand what their legacy is, so that then you can go to the next step of helping them perpetuate it or maintain it?
I think it's really just having a conversation and learning about them and what is important to them, and whether or not they care to have the things that they are doing continue to make an impact. And that's going to be different for everybody. Some people just don't care. You should care, but they're just like, whatever, I'm going to do what I want to do. And then my kids can deal with it. And that's their thing. I'm going to be dead. I don't really care. But I think especially when you're working with other financial professionals in that person's life, and you can see all the things that they've accumulated and the different ways that they're doing things and making an impact. I think charitable goals are really important, right? Because maybe you want to make sure those kinds of things continue. And people don't realize that you can't always just have that stuff continue if you don't set up the mechanism to make that happen. We actually have to put a specific provision in that says, allow my agent or my trustee to continue to make the kinds of gifts that I was already making, because you don't want to become incapacitated and you've been this great philanthropic leader in town, and then all of a sudden that just stops. And if you want to still continue that presence, out there, there are things that you need to do. So I think starting with that conversation and understanding what their goals are, then we can go further into how to we're not ever supposed to say stuff like achieve your goals, right? So but we can work best to effectuate those, with no guarantee that it will be perfect. But we can just, that conversation is where you have to start. And when we understand you and we listen to you, listening is so important. People don't realize that. You see this all the time with certain advisors who they are not listening to what you have to say and to what is important to you. And when you listen, I like to talk, but I can listen. it's going to help make that plan better, and your clients are going to be happier.
Okay, so now let's stick with your example of where someone was philanthropic, and they have, you know, either a cause or a particular organization that they favor. So what in the absence of their children perhaps being, you know, as committed to that cause or organization as they are, what can they do to make sure, or not, maybe make sure is too strong a word, but hopefully ensure that that legacy will continue?
There are lots of things. So, you know, in the olden days, right, setting up private foundations, family foundations were the things to do. Now there are slightly easier, less red tape mechanisms like donor advised funds, where you're basically creating your own nonprofit, you know, through you know, it might be through a community foundation. I'm on the board of a community foundation that does that kind of thing, and or, you know, different investment firms might have their own, and you basically you get okay, the tax deduction part, like, that's important, but that's not what the point of your question. So, you know, you could essentially create your own funds that name charities as ultimate beneficiaries, or you can name successor owners, you know, like your children, to take over administering this fund on your death and continue to make what are called grants to these various charities. That's one way people do things. If you want to have like an ongoing, you know, presence in that area, just even leaving, you know, your retirement accounts, naming a charity as a beneficiary is a really helpful thing, because it's not as tax efficient for your children to inherit your retirement accounts now. Now your kids have to take this money out. I'm not saying every circumstances, most circumstances, there's some little caveats to the things in a 10-year period. So if you have a really large IRA and your kids are in a high tax bracket and they have to pull this money out over 10 years, it's not necessarily tax efficient for them. But a charity, being a nonprofit that's not going to be paying taxes, they're not going to have the same problem. So if you're looking at, should I want to give, you know, a certain amount to charity, should I leave that in my trust, or should I do that in an IRA? It might make sense to do that as a beneficiary on your IRA, which your advisor would talk to you about, because this is not one size fits all for everybody. Right. So leaving them as a beneficiary is one way to do things. Creating a donor advised fund and naming your children as successor, you know, owners or administrators of it, that's another thing that they can do. You can certainly go the private foundation route. I mean, I usually think of that as like really big money. I mean, there's governance and all these extra rules, and it's a lot of work. It doesn't mean it's not the right solution for you, but for a lot of people, you don't necessarily have to go that route.
So all of these sound like there are at least some level of administrative costs to making them work. So at what level do people need to be financially where it makes sense for them to, you know, take advantage of some of these tools that you've discussed?
Sure. I did forget to mention there are like charitable trusts that you can create as well that aren't, you know, foundations. I would say, you know, at any level you can name a beneficiary, right? That doesn't cost anything to do. It just happens. You know, I don't know that there's necessarily a magic number. I think it's whether the tools make sense for you. I mentioned a donor advised fund, sometimes people create that because you can front load money and get a tax deduction on the front end, because now that a lot more people are using the standard deduction, they find that it takes a lot more money to get over the hurdle of the standard deduction before you can start itemizing and deducting all of your charitable contributions. And so sometimes if you're having a really big tax year or big tax event, you can front load to these donor advised funds, and then in subsequent years you're just taking the standard deduction, but you can continue to make these grants and give like you would normally give. And so a lot of times when you have conversations like that, you look at, okay, how much money does the person have? What's their income? What's the number to get over this hurdle? You know, you want to try to get over the hurdle as much as you can in that one time. And if you can only do it by $1,000, might not make a lot of sense to, have this extra account. There might not be a lot in it. You are paying investment fees usually because you want that money invested and it grows. And so, we're not talking about people. You don't have to be like, have $10 million for a donor advised fund to make sense. I mean, usually people who are really high income earners, you're making multiple six figures, where you typically are giving away a decent amount of money every year. Like it's normal for you to give $20,000 a year away, 30. If you can front load it, you might, do a couple years worth of giving into that fund. I think when you start getting into other vehicles, right, you're talking about people who have estate tax problems. That number is going to become higher, right? So in 2026, today you get like $13.6 million a person to give away without an estate tax problem. It's scheduled to sunset back, and adjusted for inflation, I think we're thinking it could be in the $6 to $7 million range per person. When you start having an estate tax problem, that's also a clue when it might be a good idea to start really getting into some of these different vehicles. And we don't know if it ever went back down to like $1 million or $2 million, you've got a lot more people that have an estate tax problem. So I think that's a really good guide. Do I have an estate tax problem? Yes or no? But it doesn't mean you cannot do things way before you have an estate tax problem.
So, you alluded to this a little while ago. It sounds like much of the tools available to deal with charitable giving do tie very closely to tax issues, right? So, you mentioned that you handle tax matters as well. How do you kind of group those together so people can start to see the benefits of examining these issues in a holistic way?
I think when you start, we give because we want to give. I don't like to encourage people to give just because you could get a tax benefit from it, right? Because you have to remember, you're still actually giving the money away, right? If you give $1,000 away, great, you might get 36%, if you're in the 36% tax bracket, you get a deduction, but you literally did give $1,000 of your money away. If you don't care about the cause, you might as well just keep the $1,000. And, I just, I'm not an advocate of just trying to find like a tax.
Right.
But I think that, I don't, it's tricky. I mean, you give because you want to give, and then we look at everything and we see, like, again, it's going back to your goals. We look at what the implications are tax-wise. Sometimes we'll do something where we'll give money to family members up to the amount that is, they're allowed to pass on without taxes, and then everything above that amount goes to charity. So we just have to look at everything and figure out, it's going back and figuring out what your goals are, and then seeing how the numbers might make sense. On a year-to-year basis, right, there's lots of little things that you can do, right? If you're over 70 and a half and you have an IRA with required minimum distributions, now the age to start those has gone up a little bit, but they still kept this 70 and a half rule in place for giving qualified charitable distributions. So if you don't necessarily need the money from your required minimum distribution, you have up to a certain amount that you can go give directly to charity. You can't put it in your hands first. You cannot make the check out to yourself and then give it to charity. You can have your investment person have you sign a form, send it directly to the charity, and it avoids being reported on your tax return. It's not going to be part of your income. It still gets reported, but your tax person writes like QCD next to it for qualified charitable distribution, so they know it's not taxable.
Right.
So we might look at that. So having those conversations and getting a sense of how much do you want to give? How frequently do you want to give? Then we're going to look at the different mechanisms that make sense. And I kind of forgot what your initial question was because I went on a tangent, but hopefully I somewhat answered it somewhere.
Yeah. It was talking about, kind of the nexus between the tax advantages of giving and the giving itself and how you negotiate that. So I liked your answer, frankly, because we should be giving because it's something we care about, right? Not because we're going to get a tax deduction.
Right.
So shifting away from the charitable giving to other aspects of the legacy, one of the things you mentioned was people have a name in a community. They're looked upon a certain way, or their families looked upon a certain way. How do you help them maintain what sounds like a fairly intangible aspect of their legacy?
That's about having the right people administering everything on your death, right? So when you're using something like a community foundation that has a local presence in the community, your name is still going to be attached to grants and things that are being made. So, I'm just making this up because it's me, but the Jennings Family Charitable Fund, right? If I'm long gone, and I've funded it well, gosh, I hope I could fund it with money that lives on in perpetuity, and they're going to make grants. My name is still going to pop up in various places when those grants are made. That's one way to do it. When you have your children administering things for you, they are going to make it a point to say, this came from this person. And that's not always important to everybody. Some people like to do things anonymously. Some people like to have their name on there, but there's certainly ways when you structure the money, when you structure the way you're gifting it, to make sure that when those grants and those donations are made, it's clear who did it. And usually places are going to publish that and they're going to put it in there. So if that's important to you, it's not that hard to do that. It's a lot harder if you just leave your whole estate a complete mess and, and nothing's done in an organized way. And that happens way too much. You're not going to have any kind of good legacy that you do that. So.
Yes. Welcome to my world. Right? As a professional fiduciary, we're basically the guys coming in with the brooms and yeah.
People don't realize how messy that is, and it's stressful and exhausting, and it takes a long time. So, and they don't believe us. I mean, it's like, I'm telling you, I'm like, I have no incentive to tell you to clean up, to do this the right way, because I make more money if you don't.
Right. Well, and something you've been saying struck me just now, and that is, especially for people who die intestate, they virtually lose control of how their legacy is perceived. And the amount of frustration caused by dealing with all of these messes. I find people saying things like, well, he was a great guy, but it's so frustrating dealing with the fallout of the lack of planning, that it kind of besmirches that image, sort of, which is really counterproductive, I would say, to the work that you're looking to do.
Right. I mean, if you're trying to leave something for other people, being organized about it is the best way to do that. And I think it's interesting when you brought up the whole intestate concept, that's dying without, for the people who don't know, right, when you don't have a will and it's going to pass by state statute. But I also think people put way too much emphasis and importance on a will. Right? People are always talking about the will, and then they read the will on TV. And I'm like, those people were not relying on their will to transfer their assets. They had a trust. And so what a lot of people don't realize is, the will, if you have kids, right? Very important, because you are naming guardians for your children. And hopefully the court agrees that those are the appropriate people. But you're still in probate. If you're just relying on a will, you're still relying on a court process, a long drawn out thing. It's public. People can see your stuff. There are costs. There are, you're paying a lawyer to file all this extra paperwork. When you create a trust, a revocable living trust, that is basically accomplishing a lot of the same things that you think of when there's a will, only it allows money to be held, for longer periods of time for your kids. When you just use a will, when your kids turn 18, they would get the money, right? Because kids can't inherit money before they're 18. So it goes into a conservatorship or a guardianship. Every state uses different terminology. Right. I think the Britney Spears thing was a great example of that, because people finally saw that word out in the real world, right. Even though in her case, she was alive, and that happens too. When you're incapacitated, you have these proceedings, but also for young children who are minors and can't manage their own affairs, you are filing things with the court. You were under court supervision. And then when they are 18, they just get the money. And I don't know about you, but I don't want my kid to just get all that life insurance when he turns 18, because then he's not going to go do anything productive with his life. So, people place this emphasis on, when you die without a will and all that. It's like, great, yes, we want to have a will. That is part of the estate planning package. But there are, we want to not have anything go into court if we can help it. And we want to have everything passed and organized in a document that is outside of that process. So when you rely on the state, when you don't have a will or anything in place, the state that you live in, that statute's going to govern how your money goes. You may not like it. You may not even know. People are often surprised. Like at least in Missouri, when you have kids, the spouse doesn't get 100%. Now, if they're a joint co-owner on an account, right? Because you can pass things to people through account ownership and contracts, insurance and things like that. But like if I just have a bank account in my name, no transfer on death provision, and it's got $1 million in it, I would love that, by the way. When I die, it's got to go through probate. My husband gets like the first $20,000 and then has to split it 50-50 with our son. So people are they're surprised. It's not going to necessarily go the way that you think it's going to go. So it can be messy and definitely not accomplish your objectives, because the state just wrote what they kind of think is right and fair, right? They don't know you. They don't know if you don't have a spouse or kids, that you don't speak to this sister or that brother or that uncle, or, they don't know. Mm-hmm. So the only way that you can make sure your money gets where you want it to go is if you actually plan for it.
So at what point, and I know this, you're not making a legal recommendation specifically, but in general, at what point do you recommend people consider creating a living trust? Because, for example, I have a friend here in California who's one of the top probate real estate agents, and his position is, if you own a house in California, you need to have a trust, because that house is, that one asset is enough to justify the expense of creating that trust. So do you have do you have some general guidance on that issue?
I think, at least in Missouri, I know we're friendlier than California is, so I am not surprised if more planning is better in California, from what I hear. So I think generally, though, for any estate planning documents, the second you're 18, right, your parents don't have the ability to get your records, if you have a health crisis, you should be getting a power of attorney for financial matters and healthcare matters when you're 18. I think, when you're young and you don't have a lot, you can, in most places, I don't know how everything works, structure things so that you have a beneficiary on all your accounts. If you've got your bank account, your 401k is going to have a beneficiaries listed. You make sure you have primaries and contingents, and you pay attention, because people die and things happen, and you don't want to just leave them there forever and forget about it. And so a lot of times that kind of stuff is okay, while you're young, to get through that. Definitely when you have kids, especially if you have any life insurance, right? And most people, we would say, when you have kids, you should be buying term life insurance, because it's cheap and it's going to replace the income of the parent that dies, and you can, continue to live and pay your bills. And so, but if something happens to both of you, right, you could have a sizable amount of money that's going to be for their benefit. And so I think definitely when you have kids, you should be doing an estate plan. And I think your attorney, if you're working with somebody who is actually an estate planning attorney, I know we're about to run out of time, but this is not like your cousins, brothers, whatever's, mechanics, business litigation attorney should not be doing your estate planning stuff. they are going to tell you what is appropriate. And, I've had cases where I'm like, ugh, not when they have little kids, but I'm like, you're so close. Like if every T is crossed and every I is dotted, I'm not going to like force you to do this. I think it's a better choice.
Mm-hmm.
But if something happens in the meantime, like you're going to have to come back and we're going to have to do this. Like if one of your kids dies or, something like an adult child. So they should tell you what is appropriate. And so you've got to have that meeting to know.
Right. And we're kind of up on time, but one other question occurred to me that I'd like to ask you. And that is, if someone has property in more than one state, and given that trust and estate and probate laws are really a state by state function, so what do they need to do in order to make sure that property is properly handled across state lines?
Yeah, a lot of times it's good to have connections with other attorneys in other states. Like I know we have a network of people that we could reach out to in Florida or wherever if you have stuff. But most of the time, I can't say that this would always work, right? But if you have your trust, most of the time, deeding the property that you own there into your trust, or if maybe it's a rental or it's an LLC, it just depends on like what the property is. But there are mechanisms to transfer title out of your individual name into something that should allow your successor trustees or the successor managers or members of your entity to be able to handle that without having to go to court. Does not mean that there won't be something that comes up, because every state has their own little things, but for the most part, when you do it, that's why you have to tell your lawyer everything. People are like, well, I didn't think it was relevant. Let us decide if it's relevant. I need to know, is this a rental property? Where do you have this? I don't care. If you own only 1/10 of it, I need to know, right? So that's why when we say tell us everything. So, and that way, we can try to make sure that we can stay out of probate court in other states as well.
Very good. Well, Jennifer, this was so informative. And by the way, you have a sense of humor. I'm thinking, if this whole lawyer thing doesn't work out, you may have a career in stand-up.
Well, I'm not going to deny I don't try to be a little funny on LinkedIn sometimes, so It does encourage me, and maybe my backup career. So
there you go. Well, I really appreciate you spending this time with us today, and hopefully, down the road we'll check in with you again, because these things do change, and like you mentioned, one of the big ones that I've talked about here on the show, which is the lifetime exemption, is potentially changing dramatically at the beginning of 2026. So really appreciate all of the knowledge you shared. So I'm just going to do a quick sign on, and if you don't mind hanging tight, we can chat for a minute offline.
Okay. Thanks for having me.
So folks, thanks so much for joining us today. I hope you found this not only informative, but enjoyable as well. And if you have any questions, Jennifer's contact information will be in the show notes. So, don't hesitate to reach out. And I'm sure she'll be happy to talk with you about your estate planning needs or the questions that you have, especially if you're in the St. Louis area. But as she mentioned, she has a network elsewhere. So, if you're in another state, I would say, feel free to reach out to Jennifer as well. I'm sure she'll help you. So tomorrow at 10 a.m. Pacific time is Business Lessons from the Military. And then on Wednesday, also at 10 a.m. Pacific time, I'm having a guest, Jock Payton, who's going to talk about special financing for businesses. So you don't want to miss Jock. He's another fellow with a very interesting background like Jennifer. So I hope you'll tune in for my other shows this week. So Jennifer, one last time, thanks so much. And hope you all enjoyed it. Wishing you a wonderful rest of the day, and signing off as I always do. Marie, you are my bell.